Good morning, everyone. Thank you so much for being here today. My name is Abby Hughes, Project Manager at Nonprofit Association of the Midlands. We are excited to have you join us for our third session with VGA panels around COVID-19 and nonprofits. Today, we will be focusing on legal and ethical issues in this COVID-19 crisis with speakers and panelists from the community to let us know what those best legal and ethical practices are around the workplace in COVID-19. Just a few Zoom reminders before we get started. We are using Zoom webinar, so your microphones and cameras are automatically turned off. If you have questions for the panelists, please submit them in the Q&A box at the bottom of your screen. If you kind of hover over our pictures, you'll see that there. And John will help the panelists answer those questions. We are recording this webinar and it will be shared after the fact. So again, thank you so much for joining us, and I will turn it over to John Levy to moderate our session this morning.
As Abby said, thank you everyone for participating in this panel discussion. We really appreciate you being here, and hopefully you find this information to be helpful for your organizations moving forward. With that said, I want to kind of get right into it and allow our three panelists, each one of them has prepared some opening remarks. After their opening remarks, we're just going to do a Q&A. Also, as Abby said, if you do have any questions, please feel free to ask them at any time. I'm not necessarily going to interrupt the panelists immediately, but we'll get to your question as soon as we possibly can. So with that, Pat with the Fraser Stryker Law Firm is going to start.
Thank you, John. Assuming that you've been reading the newspapers or watching TV and you're seeing the results of the reopening of America and you're still inclined to do it for your employees, I'm going to talk about some of the legal ramifications and some of your obligations as an employer vis-a-vis the reopening during the COVID pandemic. When employers reopen, they need to consider several things for the protection of their employees and to permit and to prohibit the transmission of the virus. The first thing is that they need to practice social distancing among the employees. Second thing is they need to make sure that housekeeping matters are in order so that they are disinfecting the workplace and frequently touched areas, and then also wearing masks at work. With respect to social distancing, it depends upon the nature of your employment. But what OSHA is requiring, or at least suggesting you do, is they are requesting that you provide some 6-foot spacing for employees and customers and clients. Other examples of measures that you can take are one-way movement throughout hallways, installing protective screens or other mitigation measures both between employees and customers or clients, limiting the number of people in your workplace and limiting the number of individuals in your elevators. They also suggest that you limit the number of seats in a reception area, that you use phones and video conferencing like today to reduce the need for face-to-face meetings. You structure and manage break rooms to reduce congestion. With respect to customers, you adopt contactless payment systems if you can, and make sure that you consider non-employees, contractors, vendors, customers, what they need to do when they come into your workplace to maintain social distancing and masks. With respect to housekeeping, that's pretty simple. You should enhance your cleaning and disinfecting of frequently touched surfaces and increase the frequency of cleaning high-touch areas in the workplace, bathrooms, touch screens, elevator buttons, handrails, etc. One of the things that you need to think about also with respect to, and you can go to the next one, Abby, with respect to the COVID virus is how to handle a COVID positive employee. You should require employees to notify you if they, number one, test positive. Number two, they're experiencing symptoms of the COVID-19 virus. Number three, they've been exposed to the virus either through a close contact or a family member. They're quarantined or they're living with someone who's tested positive or is quarantined for the virus. In those circumstances, they should be notifying you that they meet one of those situations. The next thing to consider is working from home and returning to work. The CDC and OSHA and the Labor Department all ask that if employees can telework, that you allow them to continue to do so. Now, that may raise some issues about Fair Labor Standards Act and things along those lines, but we are encouraging employers to allow employees who can telework to do so. You're going to have employees who are fearful of returning to work. Either they're fearful because they have some comorbidities, some underlying health conditions, or they have family members at home who have disabilities or comorbidities, and they're afraid of bringing it home. That's a legitimate concern. If they are refusing to return to work, even after you've opened, you need to meet with them and discuss with them why they're reluctant to return to work, what their issues are, and to describe to them what you've done to alleviate their fears. In certain circumstances, we still are allowing and encouraging employers to allow them to take unpaid or accrued paid leave for periods of time when they're fearful of returning to work. I encourage my clients to be very careful in terminating employees who do not return to work, as they may be engaged in some protected activity, perhaps under the National Labor Relations Act or other laws, and you do not want to retaliate against them for what may be protected activity. With respect to leaves of absence protocols, we are encouraging our clients to be consistent in granting leave requests. That means don't be discriminatory in how you are allowing employees to take a leave of absence and stay away from the workplace, to make sure that you comply with Title VII, the ADA, and other federal and state and local laws. You may be required to provide some payments to employees if you are covered by the Families First Corona Response Act. So if you have an employee who has lost childcare due to the coronavirus, then you're required to provide them with 12 weeks of emergency FMLA leave. If you have an employee who has the virus or is quarantined for the virus and seeking a diagnosis, you may be required, if you have fewer than 500 employees, to provide them with 80 hours of emergency paid leave. Let's talk a little bit about some of the legal considerations governing the return to work. First of all, under workers' compensation laws, those are state laws, and generally they are the exclusive remedy for an employee that is injured in the scope of their employment. It is difficult for most employees to prove that they contracted the virus at work and within the scope of their employment, and therefore it would be difficult for them both to sue you for negligence, and would also be difficult for them to prove that they are entitled to workers' compensation benefits from contracting the virus, unless they are some group of specialized employees like first responders or healthcare providers or mortuary workers who work in places where they deal with people that are positive for the virus and are treating them. In those examples, those types of employees may be entitled to workers' compensation benefits, but most ordinary employees would have a very difficult time proving they were eligible for such benefits. The next issue, the next legal issue is under OSHA. OSHA declined this year to adopt a specific standard for the COVID-19 virus. What they are focused on is enforcing the general duty clause, which requires every employer to have a safe and healthful work environment for its employees. Last week, OSHA did issue guidance for reopening businesses, and some of those were the things we talked about: social distancing, cleaning the workplace, and wearing masks. But they did provide the guidance which talks about an employer has to do a hazard assessment to determine whether or not there's a potential for COVID-19 transmission or exposure in particular jobs. OSHA, and that's on the next slide, Abby. OSHA has also said that employers may perform daily temperature checks and health assessments of employees to protect all employees from getting the infection. what is most important probably is making sure that employees are self-monitoring themselves at home, and that your sick leave policy should provide that if you feel sick, don't come to work. That's one of the most important things you can do, because you don't want to incentivize employees to come to work if they may have the virus or they feel ill with the same symptoms of the virus. With respect to temperature checks, which is on the next slide, OSHA would require that if you maintained a record of those temperature checks, that those would be a medical record, and you would have to keep those for more than 30 years, perhaps. So what we encourage people is, if you're going to keep temperature checks or screen employees for returning to work, do not maintain those records, because then you have a duty to maintain them as an OSHA medical and exposure record. OSHA also provided some guidance with respect to return to work and face masks. Before, it was uncertain whether or not a cloth face mask was personal protective equipment. That's important because if it is PPE, the employer has to pay for it, and the employer has to ensure that employees are trained in how to use them, and also that they are fit tested, like a N95 respirator. OSHA declared last week during its guidance that cloth face masks are not PPE. So you do not have to pay for them, and although it's a good idea to provide them, and you do not have to train employees or fit test them for use of cloth face masks. The reason primarily is that it's not PPE because it is not protecting the employee themselves. It's protecting other employees. So that's probably why it's not considered PPE, other than the practical fact that everybody's wearing cloth face masks, and OSHA doesn't want to regulate those. OSHA says if you cannot perform the job safely, that you must discontinue those tasks. OSHA's also got some regulations that you should be aware of. Most employers here will probably not have to record injury and illness records. If you have fewer than 10 employees, or you have a particular NAICS code, you do not have to keep these records. But if you don't, then you do have to record illnesses and injuries related to a COVID-19 case on your OSHA Form 300. OSHA, even if you do not have a duty, and most of you will not have a duty to keep injury and illness records, you do have a duty to report to OSHA if you have a death or an inpatient hospitalization due to COVID-19. So if an employee goes to the hospital with COVID-19 and you have a duty to call OSHA and notify them. If you have an employee that dies of COVID, you have a duty to notify OSHA as well. The next law that applies is the Americans with Disabilities Act. For most people, the COVID virus itself will not be a disability. That is, you would not be required to make accommodations for employees who had the COVID-19 virus. A reasonable accommodation process is, however, individualized, and there may be certain individuals that have other medical conditions that are so severe that they react in a way that makes it a disability. And in that circumstance, if it became a disability, you might have an obligation to offer reasonable accommodation. The EEOC, the Equal Employment Opportunity Commission, has made certain exceptions to their rules. Under the ADA now, during the time of the pandemic, an employer may screen a prospective employee and may ask questions about whether or not they have COVID-19 or its symptoms. And that is going to be a temporary measure. But you must screen all prospective employees in the same job classification the same way. If you have a current employee You may ask them if they're suffering from any symptoms of COVID-19. Don't ask them if they have it, but just ask about the symptoms. The ADA or the EEOC through the ADA has also provided some return to work considerations. Employers can ask employees for a fitness for duty test to indicate whether or not they have COVID-19. You are not permitted, however, and the EEOC declared this last week, you are not permitted to administer an antibody test or require an antibody test before an employee returns to work. The reasoning is that a COVID-19 test tests what somebody is presently, whether or not they have the virus. An antibody test tests a past condition that you may have had. And under the ADA, a past history of a disability is considered a disability. So you need to be very careful about if you wish to require employees to have a fitness for duty test, you don't require an antibody test.
Pat, can I interrupt you real quick? I
Sure.
have a question about something you said a couple minutes ago. The question is does it mean if you can't perform a task while wearing a mask, then are those tasks, do they need to be discontinued? Or what about performing tasks without masks but staying 6 to 10 feet away from each other? So I know those are two separate questions, but if you might want to.
Okay, so when you say you cannot perform a task without a mask, you're not required to wear a mask. It's a good idea. Unless you are in a situation, let's say you work in a hospital and you're a nurse and you're dealing with COVID-19 patients, you are required to wear PPE. If I work in a retail setting, it might be a good idea based on your hazard assessment that I wear a mask, but it may not be required unless I have a lot of contact with the public. But even then it may not be required because I don't know that I'm coming in contact with COVID-19 positive people like I am in another job. What I was talking about was if you cannot safely perform a task, that is, you consider all mitigation measures, you consider all PPE that may be available, and you still can't do the job safely, then you have to discontinue that task. And that's really an OSHA position with respect to all types of jobs, that if that job cannot be performed safely, don't do it.
Thank you, Pat.
The bottom line is that you should be sending employees home if they display any influenza type symptoms at work, and because advising them to go home is not an adverse employment action under the ADA. And finally, there were some questions that we got ahead of time about employee privacy. Employees don't lose their right to privacy, but any information that you glean from screening employees that you retain must be kept confidential. And they should be kept in a medical file. If you're going to keep them, they should be kept in a medical file separate from the personnel file. And you should not be sharing those with anyone except supervisors or people at work that have a need to know that. So if anybody has any questions on the employment aspects of COVID-19, please don't hesitate to let me know.
Thanks, Pat. And next up is Eve. Eve is with the Business Ethics Alliance.
Hello, thank you so much for this opportunity to chat with everybody. As John said, my name is Eve McLean. I'm with the Business Ethics Alliance, and I have the interesting gray area. So if we have the rules and the laws, what happens when you have put a rule in place and somebody decides that they don't want to wear a mask? Do you have an obligation there from an ethical perspective? Or should you be paying for the face mask? It's not required by law, so should you be paying for that face mask? Things of that nature that kind of come up with what's the right versus the wrong thing to do in this space. So I'm going to spend a couple minutes just discussing that concept. So the first is just high level. So what's business ethics? It's the standards we use to determine what is good, right, and proper in business. And it's important to know that there are 4 realms of ethics or morals that come in, and I'll use that word interchangeably. The first one is personal. So each person comes into your business, whether they're a customer, a client, a vendor, anybody, with this idea of what is right versus wrong and what is okay. And it's based upon the way they were raised, the experiences that they've had. So it's different from one another. The next is professional. Professional organizations create rules for how they want their groups to behave ethically. I'm with a group of lawyers today. They all had to pass an ethics test as part of entrance into the bar. And those are created to say what that organization thinks is right and good and the proper way to do business. Organizations do the same thing. They come up with rules, code of conducts. They come up with policies and procedures. They also create one step further. They come up with values. And the values are kind of like this attempt to tell you how we want you to act in business. These are going to be critical to us in this conversation we're having today, so I will circle back to values. And last but not least is societal. Societies come up with rules and laws on how they think they should be governed ethically. And you're going to see those are different in Omaha, Nebraska to Tallahassee, Florida to Saudi Arabia. So what you can see out of this is there's no set of rules. There's no 6 rules that if you follow these 6 rules, you'll be deemed as ethical or unethical. There's a lot of ways that this gets sliced and diced to coming about. So what do we look at from an organizational perspective to try to determine what our ethics are? As an organization, we work to try to create rules, guidelines, and values that are morally good and morally right for our workplace. It deals with how we treat each other, and it requires long-term thinking about serious harm and help that we might do to one another. And it's about being part of something bigger than just ourselves. So you're asking people to join your organization. That's why many people up front ask things like, what are your values or what are your culture? So if we go with that concept of culture, ethics as a verb. So a lot of times we think of ethics as a noun, something that's posted on a wall, our values, maybe our policies, our code of conduct. But this is where, when times of crisis, when things are really rough, like right now, this is when you see ethics become a verb. You take those words into actions, your thoughts and intents into outcomes. And what happens is you end up with a culture. So the decisions that you make today have a precedence to the culture that you have. So it's not just determining what needs to be done, it's determining how you need to do it. And let me be very, very clear about 2 points. Number one, you will be faced with very difficult situations. You already are, and you already know it. So this isn't a simple to do. There is going to be things that not everybody's going to agree with you on. Your organization's going to take a stance, and somebody's personal is going to say, I don't agree with that. And you have to decide how you're going to deal with that situation when it arises. So number one is you can't make everybody happy. Number two, the things that we do now create a precedence for the culture that we're building. So the how we perform these acts, whether they're hard acts or simple acts, create what the company comes to be known for, whether it's with their employees or whether it's with the general audience, whether it's with customers, vendors, any of those sorts. So if ethics are just a verb, why is it so hard to do the ethical thing? There are 4 things that often come into play. The first one is called an ethical dilemma. That's when we have 2 right answers that face us. So for example, and either one of those, taking either one of those right answers is going to come at a cost for you. That's an ethical dilemma. For example, you as a company have decided that any customers that come in have to have a mask on, and a customer walks in the door without a mask. So now we have an ethical dilemma, because on one side of it, that customer is standing up for what they believe is their personal right and freedom. And on the other side, you're standing up for what you think is in the best interest of that organization. There are 2 rights, and there's a cost associated with both of those, as we've seen on social media, as the fight has gone back and forth between my right to go someplace without a mask and your need to wear a mask. So that would be an ethical dilemma that you're being faced with, and either stance that you take is going to come at a cost. The next is an ethical commitment issue. An ethical commitment issue is, you know the difference between right and wrong, but you're getting pressure to do the wrong. So for example, if you're taking those temperature checks on the way in the door and you find out somebody does have a fever and you send them home. You actually should not be communicating to the entire organization that you sent Sally home today. Okay, but what if an employee comes up to you and taps you on the corner and says, I really need to know why Sally's not here today. I have a compromised immune system. Am I going to get COVID-19? And they start doing that pressure. You now have an obligation to, again, keep that confidential, but she really wants to know and she has a need to know, do you tell her? So that's an ethical commitment issue. And we'll talk about that one more time in blind spots. Rationalization is the next one. So in rationalization, it's the idea that we can rationalize unethical behavior, but everybody else is doing it. So therefore I can do it too. We've seen that backfire through history. So you want to make sure that you're taking stances you feel that you can stand strongly on. And last but not least is blind spots. Our brain takes in so much information so rapidly that we have a tendency to make generalizations. We have a tendency to oversimplify things. And we do that just so we can keep up and function with the info we have. But oftentimes that creates blind spots. So our inability to actually see there's an ethical dilemma involved. So I'll just give you one really fast example of that. In the ethical commitment where I said you're getting pressure to tell about an employee that just has a fever, what if that was the boss telling you that you need to inform people? So when the boss happens, a common blind spot is authority. We are wired to follow figures of authority. And sometimes people will do unethical things because they've been told to do so by a person in authority. And it's good to know ahead of time if that's something you're susceptible to. Okay, so all of that, just real quick, what do we do to try to mitigate these risks that we have? First but foremost, do not work in isolation. When you're coming up with your policies, your procedures, your ideas, talk to your attorneys and get their input. Talk to your HRs, form a little group that you're going to discuss this together and try not to work in isolation. Ask yourself a few questions. Let's go back to that definition that I gave you earlier in the day. Is this in line with how we aim to treat each other? You created values at one point in time, many of you, maybe you have not, but many of you have values. Is this in line with the values that you have? Those values you create are kind of like an unwritten contract, and I'll be careful with that again with lawyers using the word contract, but it's this kind of agreement you've made with your employees. This is the type of organization that we're attempting to build. And in return, you're asking them to live out those values. You're doing the same thing with your vendors and your clients. So you want to ask, is the course of action we're about to take in line with it? When you do hard things, if you have to do layoffs or something of that nature, is it in line with the way that you said and kind of committed you would act? Then also, what's the long-term consequences, serious harm or help that may come about by your actions now and in the long run? And then this one is one of my favorites. How do you want to be known through this? So is there a specific way that you want to be known through this at the inside? Maybe it's thoughtful, maybe it's quick, right? So maybe we want to be seen as reactive and we're quick to be in front of this. Maybe it's the other way. We want to be a little bit slow and contemplative and we want to consider the client, or maybe we want to consider the customer, or excuse me, the same one, maybe we want to consider the employee. Having that, ranking that is going to change the way you might come to your decisions and conclusions. Last but not least, assign somebody that's in that group that you're not working in isolation with to be the ethics holder. And what that means is when you're making decisions and you're having conversations, their job is to make sure that you're staying true to the self that you are, true to the core of what your company is and stands for, true to the brand that you've been putting out there, and true to your values and your reputation that you have in the industry, so that when you make decisions and you put items out there, you feel like you can stand on those firmly and that they will stand the test of time. So that's just my real quick overview on that. And I will stop sharing. Whoop. I can't stop sharing. I lost that.
Thank you very much. Thank you, Eve. And next up, Hannah with Baird Home Law Firm is going to give her opening remarks.
Thanks, John. I think my remarks on all of this are a little bit more unique in that they're very focused on the PPP program and other financial opportunities that nonprofits can use during kind of this unknown time and at a time when either donations are down or operations are down, or you're just kind of navigating through this. The PPP program has been a bit of a whirlwind since the CARES Act was passed in March. As you may know, the program has changed on an almost a daily basis, I would say, since that time, even to the point where, and I'll say I purposely don't have a PowerPoint today because things are changing too quickly. Right before we started this webinar, I was just checking all of my sources to make sure nothing had changed since the day before. And I did, in fact, have some updates to make to what I had previously thought kind of were all the rules. That's obviously made, you know, my job a little bit difficult over the past 3 months, but it's certainly made your job, for any of you that have PPP loans, not only difficult, but also just cumbersome in trying to track all of the changes and make sure you're doing the right thing and taking advantage of the PPP program, but not doing it in a way that would hurt your chances of forgiveness at the end. So for what it's worth, I feel your pain. I feel, you know, all those changes that have been occurring. I think the best way to kind of conceptualize the PPP program right now is to think of it as kind of the timeline and the progression of the law that has changed since the end of March. So my kind of opening remarks here are going to be in timeline format. And then we can kind of, as we get into Q&A, we can talk about specifics that have come up since then. So as you probably all know, the PPP program is administered by the Small Business Administration. They've obviously had loan programs in the past. The biggest part, or the biggest difference with the PPP program is these are forgivable loans. And specific to this audience, these loans are now available to 501c3 organizations. That wasn't previously allowed in most SBA programs, so that really opened the door to a lot of you to be able to participate. The CARES Act introduced the PPP loan program and allocated a good portion of the budget to that program. And as you may know, it was only a short time before all of that money was used up. And so in May, they did refund the program. I did just read yesterday that they still have over $100 billion worth of loan proceeds left to allocate. So we're thinking that they're going to extend the program. So if you're sitting, you know, if you're a participant today and you haven't applied for a PPP program, maybe because you didn't think you needed it, or maybe because you just didn't think it was the right fit or didn't understand how the program would work, I encourage you to re-examine those decisions, because there is still money out there. And it is a very, you know, fruitful resource given the fact that it's typically a forgivable loan. Through these last 3 months, I've gotten different questions about every 2 weeks. There was a different focus on the PPP program. So at the beginning, the first 2 weeks, we were all talking about who is eligible, how do the affiliation rules work if you're an affiliated nonprofit. Let's say you're a foundation that's affiliated with a hospital, for example. You obviously had different affiliation rules regarding how many employees you had, as PPP is typically limited to organizations with 500 or less employees. I think everyone's kind of gotten those eligibility questions answered. So, you know, mid-April or so, I was able to move on from that. And if, as you may remember, the big deal in April was the SBA's re-examination of the good faith certification. If you may remember, on the original application for a loan, the loan application required you to certify in good faith that current economic conditions made the loan request necessary. I consider that phrase, and I still consider that phrase, to be a very vague standard, which we all thought was a good thing at first, because we thought, hey, everyone can apply, you know, clearly the economy's uncertain, you know, and it seemed to be a very encouraging program. Well, then the SBA kind of rolled that back and released FAQ 31, which said, hey, everyone, actually, you're supposed to look towards your other sources of liquidity. And I had a minor heart attack when I heard that, because that was not what we had been advising up until that point. And frankly, everyone that I've spoken to has likewise said that that requirement, that FAQ 31, kind of came out of nowhere from the SBA. So we had a couple weeks where we were working with clients to re-examine whether their good faith certification was going to create a problem, either in terms of the civil and criminal charges that the SBA, keeps reiterating on their applications that they can bring, or just a problem with potential forgiveness. Thankfully, kind of at the end of that 2-week period, the SBA released FAQ 46, which really rolled that back. So if you are a borrower under the 2 million mark, which is a majority of borrowers numbers wise, the SBA has said you are deemed to have made that certification in good faith. So if that's still keeping you up at night, if you're under 2 million, I'm here to tell you I wouldn't worry about it. If you're over that 2 million mark, they don't give you that same presumption, but they do say, look, if we come back and we find problems with your application and we tell you to pay the money back and you do, then we won't go the criminal route. So that likewise should provide borrowers that took out loans over 2 million, a little bit of comfort. So that was kind of our big deal around that time. In early June, our big advising was all centered around the application itself. The SBA released the application for forgiveness, which I consider to be kind of a mess. It's got a lot of the formulas on there regarding what you need to track as to employees, but it was a little confusing. And shortly after releasing that application was when Congress passed the Ppp Flexibility Act, which, as you may know, just relaxed a lot of the rules through the program and frankly made it a lot easier for borrowers to achieve 100% forgiveness. Since that time, the SBA then released a new application along with separate instructions. So if you're getting into that point in your PPP loan where you are ready to start thinking about what that forgiveness looks like, I encourage you to go to the SBA's website and download both the application and instructions. Make sure you're not using the previous version that was released early June. But I think if you go to the SBA website, you'll be able to get to the current version. And for those of you that don't have employee reductions, and there's a few other ways you can get into this, there's also now an easy application that is about half the number of pages and half the number of instructions. So if you think you're maybe in that realm, I would look at that easy application, specifically look at those instructions and see if you're eligible to use that application in lieu of the long form, because I think that'll save you a lot of heartache. Aside from kind of encouraging a new application, the Ppp Flexibility Act also expanded the time in which you need to expend your funds. So it had previously been an 8-week period starting on the first day of your loan disbursement. It's now a 24-week period. That really helped a lot of people that didn't have enough payroll coming due within 8 weeks to be able to expend all of those funds. So I think for the most part, that problem has been eliminated. Likewise, the Ppp Flexibility Act now only requires you to use 60% of your loan proceeds on payroll. The other 40%, up to 40%, can now be used for certain non-payroll costs. We anticipate there might be other ways that they continue to relax the rules. It seems like every time they come out with new FAQs, and if anyone's been following the FAQs, up through the end of May, those were being published on almost a daily basis. And then they went silent from about May 27th until last week. I think during that time they were working in all of the Ppp Flexibility Act changes to the previous FAQs. But there is an SBA document. It's about 50 FAQs. So to me, FAQs are only helpful when they're a quick read. So they might have gotten too long now really to be of much utility. But I think to the extent you have questions, but maybe aren't at the point where you need to consult your attorney, accountant, or banker, I would point you to those FAQs, which do tend to be written in a more outward facing manner than, the CARES Act itself, for example, which is pretty legislative language heavy. I'm trying to think of my other highlights. Oh, I guess the other thing to hit on is kind of what I consider the 3 big rules for achieving 100% forgiveness. All 3 of these have changed since the original CARES Act, so I'm only going to talk about what's in place right now. And if you thought, that wasn't the rule I knew, that's probably because the Ppp Flexibility Act did revise that rule just a few weeks ago. So rule number 1 is that you have to spend at least 60% of your loan proceeds on payroll costs. Payroll costs is a specifically defined term. It obviously includes regular compensation, but it also includes certain sick pay, certain vacation pay. It includes bonuses, it includes severance, it includes retirement contributions, and premiums on healthcare insurance. So under the old rules, when we were trying to fit in all of this money into 8 weeks, that's when a lot of clients were using some of these subcategories of payroll costs other than what you'd consider normal compensation to kind of get to that point. You probably don't need to do that now given the 24-week extension. But to the extent if for some reason you're having trouble spending that week, or if you, under the current rules, you can elect to continue to use your 8-week period, you might consider, paying out bonuses or something along those lines rather than paying that extra or that excess back to the SBA. The second rule is what I have termed the head count rule, which says that you need to maintain roughly the same number of employees during your covered period being either your 8-week period or your 24-week period. As you had in previous times, and I won't go into the details, there's a couple different ways you can measure that amount. And if you look at the application and the instructions, you'll see that they give you, on that particular item, I think they have pretty good instructions on how to calculate who's a full-time equivalent employee, how do we determine whether they're still at full-time if, for example, their hours got cut. So I think you can work through those formulas to just make sure you're at that head count. And if you are halfway through your covered period right now, or especially if you're maybe using that 24-week period and have plenty of time, now might be a good time to do a draft of those calculations. Because if you find that actually your head count went down for a reason that doesn't fall under one of the exceptions, you might still have time to bring that head count number back up and not have a reduction to your forgiveness.
Hannah, can I ask you a quick question that we have from one of our attendees? They ask, if an organization is ready to start completing the PPP forgiveness application, would you recommend they wait for more guidance or relaxing requirements, or would you encourage them to go forward and complete that application now?
Yeah, I think a few weeks ago, if you would have asked me, I would have said, let's hold off. They still have a lot to figure out, but I do think we're finally at a point that you can be more certain of the requirements and guidance, particularly given the relaxation that the Ppp Flexibility Act has provided. And this is also, it's almost been a month now that people that applied on that very first day that the loans were made eligible are hitting the end of their original 8-week periods. So I do have clients that have applied for forgiveness already. There's not a huge benefit to applying for forgiveness sooner rather than later, other than to get the loan off your books. We're talking 1% interest. So, I don't know as that people are necessarily incentivized to apply right away. And I've talked to some clients and they've rightfully pointed out, maybe I'll wait a little bit longer and let my bank process a few so they have a good system before I try to get in there. Because I do think just with the applications at the front end, I do think there's going to be a little bit of a learning curve on the bank side.
I just had another attendee that texted me a question saying two questions. Their first question was, can they get a second PPP loan? And their other question with it is, if they fill out the application quicker now, or fill out the paperwork that they need to complete, is there a better likelihood that they'd get a second loan if they were eligible for one?
Yeah, so right now you can't get a second PPP loan. One of the certifications you need to make on the loan application itself does say I haven't previously applied for or received a PPP loan. Given that there's, by the last news article I read, over $100 billion left in this program, I wouldn't be surprised if that changes, particularly because when they passed the CARES Act, I think a lot of us all thought that this was going to be a couple month issue, or, that was all the further we were all able to conceptualize COVID-19. And now that we all kind of know that certain people may be affected, until we're to a vaccine, maybe next year, I wouldn't be surprised if they change the rules and allow, maybe just certain applicants, but some applicants to take out a second PPP loan. It's been particularly interesting because I have some clients that the original loan application wasn't very clear on a lot of the calculations. So I have clients that said, hey, under my original loan application, I actually could have gotten, $100,000 more, but because of the way my bank told me to calculate it, which wasn't correct, we find out later. But, and no offense to the bank, they didn't know either. Unfortunately, that client's kind of out of luck until Congress comes back and says, okay, we're gonna allow us, a second round, or we're going to allow, X many more dollars if you've already, taken out one loan. But right now, that's not the case. So I don't know, is that applying any quicker will make a difference.
Thank you.
Yeah. I think I had one more of my 3 rules to hit on, and then I'll kind of wrap up my portion here. So we talked about the 60% rule was number 1. The second one was this head count rule. And then the third one is called the wage reduction rule. And this just says that you can't reduce an employee's wages by more than 25% of their rate of pay as compared to the first quarter of 2020. So essentially this was Congress's way of saying, okay, we made this headcount rule, but you can't try to get around it by just cutting everyone's pay, by 50%. Again, I think this is better explained. This is a hard one to explain verbally to a group of people. So I would suggest that you maybe do a draft of your application and work through those formulas and see where you're landing. Both the headcount rule and the wage reduction rule have safe harbors that provide that if you restore your employee headcount or you restore your wage levels prior to, I think it's now extended to December 31st, then you can kind of get a free pass on that. That's very dependent on when you made the reduction. So, I wouldn't take that as applying to everyone, but it may be helpful to you. So I just suggest kind of now is a good time to work through that application, see if you have any holes, see if you have anything that's going to potentially affect your amount of forgiveness. And then, more importantly, see if there's anything you can do about it to change that before you submit your application to your bank. And with that kind of a timeline version of our 3 months of PPP, I will turn it back to John for Q&A.
Thank you very much, Hannah. So I've had a couple of people ask me if you guys are all, I know Pat said, provided his contact information, if you guys are willing to field questions offline. I think you guys all have said you guys are willing to do that and to connect with you guys. So I'm just curious, what are the most common questions you guys are hearing about, or what are the most common issues that you guys are seeing pop up over and over again right now? And maybe there's nothing too. So, but I'd just be curious for what you guys are hearing when people are calling you.
In the employment context, it's employees who don't want to return to work. Probably is the biggest issue I get on a daily basis is, what do you do with employees that don't want to come back to work. They've been working from home, or they've been out of the office for a period of time. And that's kind of a mixture of trying to be flexible with them and ethical, but they have a job to do. And if they can't do their job out of the office, and they don't really have a particularly strong reason for not coming back, then it makes it very difficult. We've had to I've had clients that have had to let people go, and other clients who have extended unpaid leave and given them, an extra couple of weeks or to get used to it. They sit down and they explain to them, these are the health measures we've taken to protect you, but at some point, I hate to say it, we're going to have to come back to work. And those employees who don't want to, sometimes are going to be left behind.
And jumping off of that, Pat, I've also, one of the unique parts of, so I'm an attorney in our corporate section at Baird Home. And so I don't typically deal with a lot of employment matters like Pat does, but something unique about PPP is when someone calls me and says, hey, I need to lay someone off, or they're not coming back because they're scared of COVID, yet I've asked them to. We've had to balance kind of what you would do from an employment context and what your rights are as an employer, and what makes sense ethically, along with that PPP forgiveness, because as I mentioned with those last two rules, you can kind of run into some trouble if you're making employment decreases. There are some exceptions that came out just a few weeks ago, firing someone for cause and similar, kind of warranted situations. But I've worked very closely with a lot of employment attorneys over this 3-month period, trying to balance, what's the best of both worlds on that.
Ours have been two kind of perspectives. Number one is, how can a group of individuals look at the same set of facts and come to different conclusions? So if you look right now, what's going on with the school districts, you have OPS looking at the same set of facts as maybe Millard looking at, and yet they're coming up with different perspectives of how to handle that. So a lot of that is that search for the one ethical rule, and it doesn't necessarily exist. And then the second thing that we've been hearing a lot about is trying to stay relevant in this space. So you have some folks that are, clients aren't needing them as much. So how do they remain relevant while still being ethical? So it doesn't look like they're trying to trick their customers into buying from them. And then you've got the other side where you have clients that all of a sudden are very, very popular. And some of them are not for the, a lot of our social services are really being taxed right now, and they weren't prepared for this onslaught of demand. And how do you keep your employees motivated? How do you keep your employees engaged and when they're continually being overrun and overwhelmed? And so those are kind of some of the instances that are facing us and facing our clientele.
And I would say, just real quick, the other kind of non-PPP and non-employment related matter I've run into a lot with nonprofits is, what can we do? What kind of disaster relief programs can we implement that are still supportive of our current charitable purpose? And while I think, it's easy, especially in the nonprofit world, to say, okay, I have my 501c3 exemption. I know I'm doing good things. Disaster relief in, either personal grants, individual grants, or small business grants, that surely is a good thing. Unfortunately, the IRS takes a little more rigid look at all of that, about what policies should be in place, watching for discrimination, obviously, among making grants. So if that's something that you've thought about from a nonprofit side, how can we as a nonprofit continue to be provider of support? And if that's financial support, I would encourage you to examine your current grant making policies, and if you don't have them, getting something more formal in place.
So what are your guys' thoughts on, people have been asking, can you make your employees take like an oath of personal responsibility? Like ethically, legally, what are your thoughts about asking employees? Like, I know Pat gave a lot of good guidance about, you know, what people should be doing at the workplace or ideas of things, you know, from arrows to masks, but what sort of oath of personal responsibility do you guys think those are good ideas, bad ideas, indifferent towards them? Depends on what's included in them.
Yeah, I would start there. It depends on what's included with them. One of the things I actually like about that is that you're being explicit. So there's a thing that we talk about in management, ethical management all the time, which is making the implicit explicit. So if you have an explicit oath, which is this is what we're asking specifically, boom, 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 and boom, it gives employees an opportunity to decide if they want to sign up for that. But if you were going to go about that, one of the things I would recommend is actually including the population that you're asking to do that oath in setting up the oath. Because what we notice a lot of times in culture is some companies come out and kind of dictate, this is the culture that I want. Now sign up to it. And they don't understand why people don't automatically adopt it and move forward with it. And so if we rush in this instance to create this oath in an attempt to kind of get loyalty, I think you may find that it could backfire. So unless you involve the population who you're asking to be part of that oath too. And then that would require you to actually lay out. So what I was saying before is that you want to come to conclusions that you can support. So you need to actually lay out why you came to the conclusion you came to this. So this is what we're asking of you. This is why we think it's important. And we're asking you to come along with us. I'd be laying that out ahead of time and having the employees actually weigh in on that and then moving forward with that. So it's a whole group effort instead of it being kind of that corporate hands down, this is what I want you to be doing. Just my own personal experience, those often backfire.
From an employment context, they're really of not much value. The law imposes, most laws impose restrictions on employers, not employees. So, you know, they really aren't very enforceable because it's me as the employer has a duty to have a safe workplace, not the employee's duty. But it does provide you with a way to clarify that the employee violated their duty to maintain a safe workplace, and may give you grounds for terminating them that are clearer than they would be. But they don't mean too much in the employment context. And in some cases, depending on how they're drafted, they may violate the National Labor Relations Act, as you can't require employees, even if you're don't have a union, you can't require employees to pledge their fidelity and personal loyalty to the employer above their rights. So you just need to be careful about how you would draft something like that.
And then what are your guys' just thoughts? One of the things that has been asked before is, what if your organization is not an essential service? Are you in, let's say the PPP dollars are also starting to dry up for your organization. What are your thoughts about balancing the financial sustainability of an organization versus also knowing that long-term your organization's going to be needed and needed to be around, but right now it might not be looked at as being a critical service? I mean, do you encourage them to furlough employees, just lay them off? What are your thoughts?
For me, well, yep. I guess I would say that if, and it's not even a pandemic, but if you have employees that you do not need, and you've complied with the Families First Corona Act, and you've complied with your PPE obligations on your loan, I would encourage employers to let employees go if the viability of the enterprise is threatened by having all these employees that aren't doing anything. I don't know that you're left with much of a choice. You need to be very careful, obviously, that you comply with any WARN Act, that is advance notice of any mass layoffs or things like that. But if you've met your other legal obligations and you have all these employees that aren't doing anything, then I guess I have encouraged my clients that you don't really have much of a choice than to lay them off.
And that's exactly right. The viability of the business has to maintain, and it's not unethical to have to make hard decisions. Where ethics come into play is how you go about doing it. Are you transparent and forthright with people? Have you done your best to protect like if you happen to be a nonprofit that hasn't paid into the unemployment benefit, have you done your best to protect those funds so that you can pay those through if the state doesn't pick those up? I mean, are you thinking through these whole things so that you're trying to act in the best interests of all the parties involved, so that when you come through this and it's time to hire those employees back up, that they still want to work for you. So being as transparent and honest as you can be will go a long way with people.
Thank you. So one of the questions I don't even know if it's a question that a lot of people have been asking me, but when I've been meeting with nonprofits through Zoom, a lot are saying right now that they just feel like everything's a moving target and that things are changing so much right now that they just want some certainty about, what they should be doing right now in order to, they don't want to expose themselves to unnecessary liability. So whether it's PPP or whether it's, some of the things that you mentioned, Pat, about the workplace itself, is there any guarantees out there that if you do the following that you are going to be, like, hey, we're right now requiring everyone to wear face masks, everyone to do temperature checks, everyone to social distance, we're only having our essential employees come in. I mean, are you still like, that's good, but I can't tell you when you're protected?
Well, I think as an employer, if you're doing those measures, the social distancing, the frequent cleaning, the wearing masks, and you are being as flexible as you can with employees about the return to work and working from home, you can pretty much be assured that you are not going to face any legal exposure if someone catches COVID at the office. I think that's a pretty safe bet.
I think one of the tricky parts when it comes to legal or ethics is it's all risk mitigation. So we're doing our best to mitigate our exposure to potentially liability or lawsuits. And from an ethical perspective, you're doing your best to mitigate against reputation damage and consistency, being known as the ethical company that you are. So that's what makes this so difficult, is that there isn't a long precedence that teaches us that these are the things that will land on the right side of history. Which means right now we need people to be tremendously not only flexible, but to have the fortitude to continue to flex through these uncertain times. This is not going to be a 3-month exercise. And the clarifications for laws and reputation are going to continue to come out beyond these next 3 months. So I think what I would say here is this is really difficult, and we need to be prepared for longevity, and we need to be prepared to continue to be adapting for quite a while.
And then, Hannah, what about PPP? I know you went over kind of here's how to maximize forgiveness, but do you still see, if everyone follows those kind of 3 rules you set forth, that they're going to be good shape? Or are you like, there's still kind of cross your fingers and say a few prayers while you're at it? What are your thoughts?
Yeah, it's certainly changed. The 3 rules have always been there, at least in some form. So I do continue to believe that those are going to be your 3 measurements for obtaining forgiveness. I think if you are someone that is looking for some more certainty right now, I would fill out that application today, see how those formulas and calculations work out. And if you're hitting at 100% right now, then you're probably doing it right as far as PPP is concerned.
Okay. And I don't know who wants to take this question, but question from one of our attendees is, can organizations that have several tenants in their building put guidelines and parameters in place for their tenants? And if so, what type of guidelines should be followed, and what happens if they do not follow them?
Are they the landlord?
Yes, I assume that they are the landlord.
Yes. I think you can, as the landlord, you can establish protocols and especially in common areas, that when they come to work, they only ride one in an elevator at a time or things like that. Yes, you can establish those protocols as the landlord.
Yeah, I mean, I office in the Kiewit Plaza, and it's pretty much, all Kiewit employees except for a couple floors, and they have everywhere written kind of the policies that they have in place themselves, even about outside visitors not being allowed, things like that. So, and seems decently reasonable to me for them to do so. When you guys think about organizations in going down, I know, I'm not asking you guys necessarily to play soothsayer or prognosticator, but do you see any new issues arising for nonprofits that haven't already, been addressed as this pandemic continues to go on? Or do you think we're going to still see some of the same challenges that we're already facing, just more in depth?
Yeah, I think one thing that we can have on our mind, and this isn't probably necessarily where most people would want to go, but just like you do in any recession, there's going to be, not every organization, for-profit or nonprofit, is probably going to come out the other end in as good of a shape. So one thing to think about from a financial perspective, if a certain organization is struggling, is whether a merger or other combination with another like-minded nonprofit would make sense from a strategic standpoint. That would more be I think, financial move than much else. But I guess and we frequently work with nonprofits in M&A type work. And I'd much rather see that than see a nonprofit need to dissolve and just pay out their money somewhere. We want to see those missions continued. So I would maybe, and that's maybe looking a year out or so. But I would put that in the back of our minds as a potential area that, well, I don't really want to see it grow because I want everyone to come out of this okay. That's worth thinking about. And I guess on a brighter note, if you will, from the nonprofit standpoint, the CARES Act did impose some additional incentives for charitable contributions. So to the extent you have a good rapport with your donors, particularly small dollar amount donors, and are able to send out, email blasts or whatever that may be to try to encourage those donations, I would do so. I think the biggest one would be that now there's going to be a $300 above the line deduction for charitable contributions. As you all probably know, prior to the CARES Act, all charitable deductions only came through if you itemized. And after the Tax Cuts and Jobs Act, itemization has gone down to less than 10% of the population, I think was the most recent stat I read, which is really unfair, I think, to charitable organizations who kind of relied on or hoped that that would be incentivizing to people. Now, at least for 2020, we can look for above the line deductions, I think up to $300.
Yeah, the one advice I'll give you from a fundraising side of it too is just assume whatever you send, even if it's to your individual donors, that it's probably also going to go to a foundation. So if you're going to send a sky is falling email, which several organizations have done, just know that that's eventually going to get forwarded to someone else. So, we're going to be curious also to know your financial picture. Pat, a specific question for you on that kind of what I indicated about what do you see if this continues to be in this current predicament. If someone had asked me, they said, hey, we are kind of just letting people work from home and didn't really think twice about it. Now they want to have kind of a work from home code of conduct because they've started to see some issues that have arisen as people have been working from home, whether it's, on Zoom calls that they're dressing a lot more casually, or they're showing up late or leaving early from meetings or different things like that. Do you encourage, and Eve, I ask you too, do you encourage people to have like kind of a code of conduct policy related to work from home, especially if this continues on?
Yes. And the casual, you know, and I gotta just admit, I haven't worn socks since March. So
Yeah.
the problem is people, and maybe it's not a problem for some employers, people like to work from home. And some people are very efficient, some are not. Those that are not, I think you need to make certain that they are productive or they come back to work. And there are certain positions, we go through this ourselves at the law firm, that there are certain positions where you need collegiality and teamwork and those types of things. There are other positions that you do not. And it is creating morale problems because some employees are allowed to work from home because their job duties permit it, and others are not. And that causes resentment within the workplace. It is important that that be addressed, and that employees who, because of their duties or because of their abilities, are not able to work from home and be productive, that somehow you need to monitor that and rein them in and bring them back to work if that's necessary. So, yeah, everybody is going through that. And everybody asked me, they said, you know, even when I help with personnel matters here, they'll say, well, you know, she doesn't want to come back. Well, why does she? Nobody wants to come back to work after you've been away. I mean, everybody's going through that. And you just need to make certain that it isn't a culture change so that employees become, that they expect that that's the way it's going to be and they're entitled to work from home. Because we should recognize that this was an exception, and it will continue to be an exception. But at some point, we're probably going to, not completely, but we're going to get back to normal where people come into the office and work. But there will be some people that never come back. And if they're able to do it, that's fine. But you need to monitor that, both productivity, and if their job duties change, they may be losing exemptions like an executive exemption or a salesperson exemption from the Fair Labor Standards Act because their duties have changed so much. And you need to make certain that that their duties continue to comply with the exemptions that they have if you pay them a salary and those types of things. So you need to be aware of that and monitor that to make sure you aren't inadvertently creating some wage and hour issues where employees now claim, well, look, I was a supervisor, but I'm at home now. I don't supervise anybody. And now I'm working 60 hours a week from home and you need to pay me overtime. Those cases are going to start bubbling up. And so it's something you need to be aware of and monitor, I think, on a consistent, continuing basis.
What I'll add to that is that working from home and remote working is not new. It hasn't been new for a while. So previous to this role, I worked for an international company and my boss was out of London. So I often worked remote, and I worked remote from my manager, and I was in a technology industry. So we had many groups of individuals that were working remote. Here's what we found. You need to be clear and explicit with the expectations of what's required of the job. And you need to do that for any employee, whether they're in the office or whether they're remote. You need to create technology that connects people and be explicit with the environment that you're trying to build. You need to be accessible via Zoom or via chat or those things. So we use tools that make ourselves more cohesive as a team. So instead of walking to somebody's desk, you Slack somebody. So you create these expectations. And again, it's about making the implicit explicit. So if your job is to have a butt in seat from 9 to 5, that's one thing. Most of our jobs nowadays have an output. This is what you're expected to do in the amount of time you're expected to do. And if an employee is not doing that, then a manager should be following up with that employee, should be documenting, this is the expectation that was set, this is when it was or was not met. The employee has a right to know if they're not meeting expectation, and they have the right to be given the opportunity to correct that. And if you have to go down the path of termination, you need to have these documentations that said, I have been explicitly explaining what needs to be done. So in my experience, I find it's best not to create rules for exceptions. If you have employees that are not behaving, you should be managing them through your performance system immediately, regardless of if they're in the office or remote.
Thank you. And I know we're basically out of time right now, but just one last announcement. The PowerPoint presentations are going to be made available. A few different people have asked about that. So they will be made available. Thank you to all the panelists for taking the time to come in and provide some guidance and advice, especially during these uncertain times. And thank you, Nan, for hosting with VGA.
Thank you, John. We really appreciate everyone's time today. Thank you to all our panelists. Be on the lookout. I will be sending an email shortly with the recording link as well as those PowerPoint slides. And happy to connect anyone who has further questions for the panelists. So thank you all. Please keep an eye on NAM's training calendar. We're always adding just-in-time trainings right now to help you through this process. So thank you, everyone, and have a good day.
Thank you.
Thanks so much.